Fabulous. Okay, thank you, everybody. So yeah, apologies again. It's great we're getting the questions in. I'm not complaining about that at all. But yeah, apologies we couldn't get to them verbally. But like we said, we'll get Michael to answer them typing away. I don't know. I have to do the actions, but I feel like it helps everybody. So we are going to move on to our final speaker before we got some news and updates. So we've got Ben Meredith from Trustmark and going to be covering specifically consumer rights and what they are and why they're important to you. And yeah, maybe talk a bit about Trustmark. Ben, hi there.
Good morning. Can everyone hear me okay? Just
Yeah,
check
perfectly. Yeah,
working.
wonderful sound, and your video is perfect as well. So yeah, without further ado, I'll let you share your video and leave you to it.
Right, yeah, bear with me, folks, whilst I just get this set up.
Right, I'll
Um,
keep an eye on it for you, make sure it pops up nicely.
yeah, so bear with me. Multitasking isn't my forte. So hopefully at some point in the not too distant, you'll see a title slide pop up.
There we go. Great. Perfect.
Excellent, excellent. Right, thank you, everyone. Great to be here this morning. Hope you've had a good morning so far and some really interesting stuff in that last presentation I saw. I'm kind of thinking in my head, it's just in my house. Can I justify any of that stuff? Because I love a gadget, and that sounds like a really interesting bit of kit there. So just to introduce myself and Trustmark. So I'm Ben Meredith. I'm consumer director here at Trustmark. Trustmark is the government endorsed quality scheme for work in and around the home. So covers a broad range of things, including obviously pest control. But some of the more sort of traditional stuff you might think of around roofing, builders. We've got quite a big role in relation to supporting net zero as well, and overseeing quality in that sense. I've worked in consumer protection for about 20 years. And obviously, before any of you guys say it, I know I look too young for that, but it's getting on very, very quickly. What I'll aim to cover today, if I just move on to the next slide, is a bit around, well, what are consumer rights? Because I think what the law says and what I think sort of the jungle drums might say can be different, and there can be assumptions about what people's rights are that aren't true. A little bit about what the remedies are. So if things go wrong, what are folk entitled to? Um, some tips around how to handle complaints. Inevitably, if you're doing anything, occasionally things may go wrong, or there'll be a difference of view around certain aspects. So it's something that will come to us all at some stage. So just some support around that. And then I'll look to finish up with why is it important that we have consumer rights and what the benefits are and where you can go for support. So I'll just move on to the next one. So what are consumer rights? I think helpfully they appear in lots of different places, which when you're busy trying to do the day job is some additional admin and confusion you probably don't need. First and foremost, the main place that any sort of rights or any particular aspects of the job it is you've agreed to do should be written down in a contract. And that contract will be the agreement that you've got with your customer about what it is you'll do, when you'll do it, any conditions associated with doing that thing, any limitations to that thing. I probably ought to have put in the slide, and payment terms. So the contract will be the first place that anyone would go to look to see, well, what's a consumer entitled to? What would they expect? And that would normally be in line with what's been agreed. Now, in 2015, there was a bit of legislation that went into being called the Consumer Rights Act. And what this does, it did two things really. Firstly, it replaced what are a number of disparate, or what were a number of disparate consumer rights that were in a load of different bits of legislation. So if you were buying goods, it was in the Sale of Goods Act of 79. If it was goods and services, there was an 82 Act around this. And there was lots of bits of piecemeal stuff floating all around the place, which, whilst it wasn't necessarily rocket science in what those things say, trying to lay your hands on where that stuff is was really difficult. So what the Consumer Rights Act did in 2015 was consolidates that into one place. So now we're kind of getting to a point where a lot of that stuff is now in one place. If you want to look things up, it's one place to look it up. And that's really, really helpful. Now, I would imagine the audience today, this is mostly around service provision. And what the Consumer Rights Act says is that any services need to be provided with reasonable care and skill. So that's to say, basically, you're competent to do the job, you're able to do the job, and that the norms of that sort of profession or that service or whatever should be applied, and people should come to expect that. If you haven't agreed a price, then a reasonable price should be charged. So normally you'll agree a price for your services, and that will be part and parcel of the contract process. Believe it or not, some people go into contracts where they haven't actually agreed a price. And what the Consumer Rights Act does is inserts these requirements into a contract. So if you haven't expressly covered this stuff off, and even if you have covered this stuff off, this is what's expected to be in a contract through the legislation. These are the sort of statutory rights aspect of it. Work should then be completed in a reasonable period of time if that's not agreed beforehand. So you've got a contract to do this thing. The thing shouldn't take far longer than it needs to, so that anyone sort of put out or anyone has like a never-ending contract. The idea is these services come in, they're delivered in what a reasonable time for those services will be delivered. They should be as described. So if you say that your service will do anything, if you advertise anything about your services, whether it's deals, whether it's how effective they are, whether it is anything around that sort of stuff, that services should be as described. The last bit isn't quite in the act, but I just wanted to sort of flag around omissions and professional diligence. And one thing that might be relevant here is just to flag with any consumers you deal with that actually, if your treatment may not be wholly effective in one go, or that things may go backwards. So if they've had some sort of infestation and you've treated that, but there is a problem next door or some underlying cause that also requires addressing, then obviously whatever you do will only deal with that issue, and there might be a risk of recurrence. And what the expectation there would be is around just flagging that, because that's something that would be important to someone when they're deciding what services to be applied and what would be a reasonable service that they receive. Now, I flagged goods briefly, and that's because it might be as part of any kind of services that are provided that goods are handed over. So that may be traps, that may be things that consumers can purchase off of you to sort of self-serve to some extent or maintain. Now, if goods are provided as part of a service, you may have seen some of this stuff before. So those goods need to be fit for the purpose. So that should deal with the problem they're facing, and they don't need to be over-engineered, or they need to be suitable for what it is that product has to deal with. It should be as described. So again, it should be exactly what it says on the tin, and it should be satisfactory quality. And that is to say that this stuff should work and should be expected to work for a reasonable period of time. That will be a matter of fact in each case. There is a thing called a reverse burden that's put in. So basically, if something goes wrong in terms of goods within 6 months, the assumption is those goods were faulty to start with, assuming they're meant to last longer than 6 months. So it puts that burden on the trader to demonstrate those goods were fine when they handed over, and that's quite hard to do. After 6 months, it will be on the consumer to demonstrate these things weren't of satisfactory quality, and that burden goes back to how it used to be. Now, if there's any issue with consumer rights and you get a complaint, ultimately, these are the remedies that the law says that a consumer would be entitled to. So the first one is about repeat performance. So if it didn't go as expected, the expectation would be to redo either the whole service if the whole thing failed or didn't achieve, or redo the part that didn't achieve, just to kind of make sure that anything is addressed fully. That's normally what most come to expect. That's kind of what the law expects in the first instance, is basically you have a go at redoing it and putting right what didn't quite go right the first time. Now, sometimes these things can't be repeated for whatever reason. There's a number of completely legitimate reasons for that. And if it can't be done, or it can't be done without creating a real kind of issue in terms of time or inconvenience, then the consumer might be entitled to a price reduction. So that is to say, okay, it was £2,000 for doing this, the last 25% didn't work, so we will give you a price reduction and therefore refund of £500, for example, just because the maths is easy for me. Consumers, if they do receive goods, have a 30-day right to reject them if they don't meet their statutory rights. That's slightly different to if stuff's provided online. There's a completely different regime around that, which I wasn't intending to touch on today. But they have that right to just reject it, and essentially that contract for the goods is almost as if it never existed. The other thing to flag here in terms of remedies, although this is a kind of broader contract and tort law thing, is that if the consumer suffers any quantifiable and consequential losses, then they may be entitled to compensation under either breach of contract or potentially negligence. So whilst that doesn't sit within the Act, I didn't want to do a completely new slide just to kind of cover off that point, but I did just want to mention that briefly, that there may be that. So when you're engaging with the consumer, you might want to just have that in the back of your mind that they could be entitled to stuff, but they have to be able to demonstrate there was a loss that they suffered. And ordinarily, whilst folk might make a goodwill gesture for any inconvenience or any other bits and pieces, the law doesn't recognise that in terms of consumer rights and consumer services. It's more if you can say, well, actually, I spent £5 on the phone chasing stuff. I had to spend X amount on something as a direct result of this, but they have to be losses that are consequential, and that means they flow from any failure, and they've got to be able to say what it cost them. And if they can't do that, then they won't be able to claim those rights. Now, again, helpfully, there was a completely different set of legislation that covered unfair contract terms, and that's been brought into the Consumer Rights Act as well. And essentially, the rule of thumb to try and keep it simple is if something's introduced in a contract that would create an imbalance of power between yourself and the consumer in your favour, then that term is likely to be considered unfair. There are some examples in there. So, for example, if you wanted to say, sold as seen, which you quite often see with car sales and all that kind of stuff, we've certainly used to, that would be an attempt to limit or exclude someone's statutory legal rights. That can't happen. It would be an unfair term. If there's something where you may give yourself sole discretion to decide on certain things and the consumer doesn't have any say in that or doesn't have an equivalent right in the contract, then that's likely to be unfair. And another one we see is around unnecessarily high cancellation fees or default charges. So if, for example, a visit is cancelled at the last minute, you can't necessarily charge a huge amount unless you can demonstrate that you suffered a loss as a result of that, and that's a reasonable loss. So these are the sorts of things that the Act recognises as what we've seen in the past that will be unfair contract terms. And the effect of these is that if a court looks at them ultimately, they'll be considered not binding. So it's almost as if those terms are never there. But again, worth flagging that just for your awareness, because part of this is when you're dealing with disputes or dealing with issues with consumers, if you know what they're entitled to and the extent to it, you can help advise them and signpost them, and that may help manage expectations further down the line. Now, you'll be pleased to know there's another bit of legislation. This is what they didn't quite wrap up in the Consumer Rights Act, unfortunately. And this is to do with contracts that are made in people's homes, ultimately. So what this legislation came about because of a whole host of high pressure in your house sales, certainly in the double glazing industry, as was certainly the home improvement sector, where people will come into someone's door saying, you need to have X done because your house is in danger of falling apart, or we've got this fantastic deal and I am going to sell you to the cows come home and I won't go anywhere until you've agreed anything. And that was what that sort of bit of legislation was kind of brought in to deal with. There's some requirements there that I won't repeat necessarily because I think everyone can read and take this away in their own leisure. It's for certain jobs costing more than £42. Really, really strange. And that was based out of the fact that this was originally a bit of EU law. And that was the exchange rate for jobs. So I'm guessing it must have been a €50 and upward job. And the exchange rate at that time was 42. The numbers never changed. No one's ever updated that, ever. Since that, it's always been that amount since I've been involved in the profession. Now, these regulations apply if you agree a contract. So if you go and visit someone's home, agree it, they sign up and they want to do something there and then, or they want to do something where you'll come back the following day, but the agreement's made in their home, this is where these apply. If you come away from it and they have time to think about it, and that's really what the mischief here was about dealing with, and they then ring you later on and say, yeah, I want to go ahead, then these don't apply. So that's kind of the key thing to just remember is if you kind of do it all in one at someone's home and it's all agreed, whether or not you start that day, that's where this bit of law will apply. And the upshot is you need to give them a cancellation notice that tells them what their consumer rights are. There's a load of specified information. And basically, if you don't get this right, the effect is that the consumer doesn't have to pay you and you may commit a criminal offence associated with that. So it sounds quite heavy for what is largely an administrative error, but that's kind of to deal with some of these things where people were having stuff sold to them at many thousands of pounds that they either didn't need, didn't want, or felt obliged to take advantage of. That kind of sets out what the statutory position is. Hopefully, these slides will be circulated afterwards, so if people want to look at it, it might help as a quick reference guide. But as I said, inevitably, when we're doing stuff will go wrong. It's human nature. And I think the first thing is to make sure it's really clear for consumers how they should complain to you. The risk will be you receive complaints in a way you don't want to receive them. They don't know where to go, and it increases the frustration. And actually, you can make things a lot easier and have a lot more of a kind of more comfortable conversation with the consumer if they're clear on how it is to complain and they've got a route in to do that and they're clear what that is. I think the next tip will be respond quickly, sort of take it seriously that these complaints, they can escalate, remain calm, because some consumers don't know how to express themselves properly. They may be vulnerable, they may be upset, and that will come out in what they're saying to you. And I'm guilty of this sometimes as well, but sometimes you just need to take 5 minutes, remain calm, and then just keep them informed. One of the biggest things we see both at Trustmark and in my previous life in trading standards and consumer protection was actually that failure to communicate or to keep people informed of stuff is what kind of really irritated folk and made that sort of situation worse. So again, if there's any advice I can give, it's just to keep people in the loop as to what's going on and why things are happening and why things are taking the time they're taking to resolve. I think the other thing is to sort of thank the customer. It will probably feel that you don't want to do that, but obviously these are your customers. These are the people that will spread word of mouth in the longer term. So thank them for taking the time to raise it with you. And then the key thing here is around confirming exactly what it is they're not happy about and exactly what they would like done to resolve it. Again, all too common. People will tell you that they're unhappy and they're unhappy about something that isn't specified and they don't really tell you what they want. Well, if you don't know exactly what the issue is and you don't know what it is they're after to expect it, it's really hard to manage expectations. It's really hard to follow up. And what these things have a habit of doing is when you're going through this process later on, new things will crop up, things that are unrelated try and get into a complaint. And actually, you can avoid a lot of that if you are really clear at the beginning about, okay, exactly what is it that you're unhappy about. And if you could give me a sense of what it is you're after to resolve it, it might be something you can accommodate, it might not, but at least you know what it is they're looking for. Ultimately, if it's wrong, put it right. Don't be afraid to apologise that these things happen and acknowledge the stress and inconvenience caused. Doesn't mean that they're entitled to any compensation or anything as a result, but quite often people will think about how they felt about stuff. It's not necessarily whether it's right, wrong, or indifferent, but if the communication is such that it rubs them up the wrong way, even if you did all the right stuff, they will still take a negative view of your business and by extension, the profession. And we certainly see that in a lot of sectors, car sales, home improvements for sure. So again, just kind of flagging that. None of this is rocket science, by the way, and easy for me to say, really challenging sometimes to do in practice. Also, sometimes you'll get complaints that there is nothing wrong. So the consumer might have decided that they're not happy with the quality of what's happened. They might have read a little bit of information online and got the wrong idea. So again, with all this stuff, be very clear about what it is they think is wrong and exactly what is required to put right. If you've had a look at it and found that there actually isn't a problem, if you can outline why there's not a problem, that will protect you down the lines. And I think the biggest tip is to maintain records or keep records. If you've got a record of what happened and when, if anyone needs to follow up, if you need support down the line, if a complaint escalates and they do occasionally do that, then obviously you've got the records of what you did, when you did it, why you did it, and all that kind of stuff. And that really does protect you in the longer term. Now, why are consumer rights important? Well, I think first and foremost, it's the law. And the reason it's the law is because I think by design, we don't get that right as a group of humans. So we have that norm written into the law about what everyone's expecting to make sure there's a level playing field. Now, one of the key things with this is that if consumers aren't confident to engage, they won't want to spend money or they will be unhappy spending money. If they're confident in transacting, they will spend loads of money on stuff. You certainly see this in other areas. So if you look at sort of online sales, and I'll pick Amazon, but many other websites and whatnot are available. People are hugely confident to engage with that organization because of the services they provided. They understand the risk associated with it, and they've made it very easy for people to spend. And then generally speaking, things are picked up. Those consumers are confident, and that's a thriving area of the sector in terms of the online sales and that platform in particular. The same reads across any sector. If consumers aren't confident to do anything, then they'll only do stuff in an emergency if they absolutely have to. And that's self-limiting in that respect. Now, the other thing with consumer rights is obviously it's the law. Confident consumers will grow the market and then there'll be more business for you. It also drives healthy and fair competition, rewarding the businesses. So if you are upholding consumers' rights, looking after them in a customer service sense, These guys will be your marketing. So when they speak to their friends, their neighbors, their family, their colleagues at work, they will say what a good experience it was working with you or working with colleagues in your profession or your organization. And it means that you're more likely to get business that way. Equally, the reverse is true. I think there's an old thing about bad news spreading 10 times faster than good. You only have to look at various news sites to see that most of that is bad news. There's not much in the way of good news on that. So that's a really key thing there about that fair competition thing. And obviously where businesses aren't behaving or aren't doing what they should do, consumers will choose not to use them. And if they continue doing it, obviously they do eventually fall into the crosshairs of various regulators. Now, with all that healthy and fair competition, that drives service improvements, it drives innovation, it drives more competition, and actually ultimately improves the experience for both consumers and the sector. So there's loads of stuff around this sort of that economists have done, but that's kind of why it's important in a broad sense. Now, the question you're probably all asking yourselves is, firstly, why am I still talking? And secondly, what's in it for me? Now, if you get it right, then consumers will build trust with you. They will ring you back if they have issues in the future. They will ring other colleagues in the, BPCA. They will ring other people because they are happy to engage in your services. And that will help everyone grow and sort of, the tide rising lifts all ships type scenario. It will help distinguish your business from poor businesses and bad actors. I think another thing we see is around online reviews is that quite often people are quick to turn to social media to flag anything that did go wrong. And they're quite quick to put that on various online forums. So actually, by getting it right, you distinguish yourself from all of the other competitors in the area who are behaving in the right way. And consumers will let other consumers know about that. If you get it right, you will ultimately save time. No one likes dealing with disputes at any sense of it. I don't enjoy it in my role. I wouldn't enjoy it if it was my business, and I certainly don't enjoy it from the consumer perspective. If you're dealing with disputes and you don't get these things locked down as to what is it exactly what's wrong, you don't deal with it quickly and nip things in the bud, then they escalate, then they can become a real drain on your resource, a real drain on your time, and a real drain on your sort of emotional capacity. And this is all time that could be spent towards growing your business, spending time with your family, whatever else you're doing. So actually what you can do by getting this right is you avoid those issues escalating, or certainly avoid the amount of time you have to dedicate to those issues. Kind of extension of the first point, really, increased satisfaction with more business. People will be more inclined to spend money with you in the longer term whenever they have an issue, and more likely to engage in the sector. That will give longer term sustainability and stability for you. And obviously, by getting it right, you will never fall into the crosshairs of any of the regulators that are operating in this space. Final slide before I wrap up and for questions. Is about where can you get support. So BPCA have materials on their website in terms of code of practice on consumer rights. That's really good, doesn't take long to work through, and covers some of the main points that I've kind of highlighted here today. From a Trustmark perspective, we have a code of practice and a customer charter, which outlines our expectations and also gives a little bit more detail on the various legislation requirements. So if you wanted something that was a bit more in depth than what I've just gone through at a high level today, I would certainly recommend having a look through those. The other thing we do that is potentially a real benefit is by your Trustmark portal access. Now, I say this as someone who doesn't access it myself. We have trading standards approved contracts and cancellation notices. So we have a relationship with Buckinghamshire and Surrey trading standards. And there's a government initiative called Primary Authority. And the upshot for that is it's all very well for regulators to tell us when we got it wrong, but actually, can they tell us when we get it right and help us get it right? And what we have there that's available for you guys for free is access to approved contracts and approved cancellation notices. So if you want to build that into whatever you've got in terms of your own company documentation, then you can use that safe in the knowledge that those things are backed up by trading standards and they tick all the boxes they need to tick and give all the information they need to give and help you sort of save a bit of time trying to reinvent that wheel. I'll signpost to another organisation that we work with. So there's an organisation called Consumer Friend. We've worked with them now for probably a couple of years, I'd say. And their aim is about trying to make consumer rights easy and understandable, take some of the jargon out of it. I've slipped into doing some of that today. I'm well aware of it. But their mission is to try and make consumer rights simple and easy to understand. And one of their things that they try and do is that everything takes 2 minutes. So if you want a quick reference guide, you would do worse than to go there. And then the final one is just highlighting another service called Business Companion. Now, this is advice that's delivered by the Chartered Trading Standards Institute and various trading standard officers who are experts in this space. There's a load of real in-depth guides and quick guides and a whole host of things there. So if you really did want or need to look into this kind of stuff, all of that stuff is available completely free of charge on the internet for you. So again, loads of support out there if you need it. And that, I think, brings me to the end.
Great, thank you, Ben. Yeah, amazing and really easy to follow and understand the bits you were covering, and really important, at BPCA, for our members, certainly, we're, very keen on promoting that, excellence in service and driving professionalism, but also, things do go wrong. And when they do go wrong, it's knowing how to deal with it. I mean, at BPCA, so I deal with complaints in the BPCA. They all come to me because, like we say, things go wrong, and sometimes you need a mediator in between. If they can't resolve it with a member, like you say, the consumer really needs to go to them and hopefully can resolve it themselves. But if not, then they can come to us, and we're actually an alternative dispute resolution provider, sort of scheme provider, or accredited by CTSI. So yeah, we've got quite a rigorous process, and we're passionate about it. And yeah, it's really good for you to give that overview on some bits. But I mean, in terms of we haven't got any questions that are coming, but I think to help the listeners. So yeah, no, that's it. And I think it's also, lots of thoughts going on, and they kind of maybe don't know what to ask. It's maybe a new area that they kind of put a lot of consideration to, I suppose. And I'm just making assumptions there. But one sort of, I say, real-time things I get, a very common issue that we get is, for example, pest controller goes and does, a 3-part bed bug treatment, and at the end of that 3-part treatment that they've charged, whatever, I'll just chuck £300 out there. It could be a lot more, it could be a less, but let's just say £300, 3-part treatment. And at the end of that treatment, the customer says, well, it hasn't worked. 6 weeks later, I've still got an issue. You need to come back and carry on with that. What's the standpoint in terms of, because obviously the customer won't want to pay any more money because they've paid a certain amount for the service they thought of providing, but then the pest controller might say, well, that's my treatment. I said it was 3-part treatment, but maybe they haven't been descriptive enough. I don't know. What's the kind of rules around that you think? I'm not saying you know the answer, but what's the standpoint?
Yeah, I mean, as ever, and the usual get out with this sort of stuff is obviously you have to apply it to the facts. And the way these laws are written is they're very principle based, which is great because they can cover all eventualities. But what isn't great is they're not really, really specific about stuff. So what you don't have, sadly, is a really hard and fast line. What I can say is if someone does that sort of treatment and it's a 3-part treatment, and that's the industry standard, and the industry standard is that it will work 80% of the time, but sometimes it may not, and additional treatments are required. As long as everyone is upfront about that, and it's clear that that's the standard, and that it isn't necessarily 100%, guaranteed, as long as no one's making those claims, then I think it would be reasonable to say, well, look, we did do that. That is the treatment. It does work in most circumstances. This appears to be a sticker issue where further treatment is required or a more acute case or whatever it is. But obviously you need to be able to stand by why that didn't work. Because the challenge will be that those services weren't fit for purpose. They weren't carried out with reasonable care and skill because they've still got a problem. So a lot of this comes down to sort of communication and just flagging that this isn't necessarily the silver bullet if it isn't a silver bullet.
Yeah.
And if there are other, I think I mentioned it earlier, is if they do a treatment, but there might be some other issue either next door or some other way that these things are getting in, because again, what might be really hard is you treat the home and then someone's bringing this stuff in, or a pet's bringing this stuff in. I don't really know how this sort of stuff works, but someone didn't invent that in their house, did they? It got in some way. So if that route into the house still exists, then it's likely you'll have a recurrence. So again, some advice about where that might be coming in so that they can be aware of things to change as well. That helps you in the longer term, because obviously there's still an issue. It'll be pointing squarely at whoever's done the treatment, won't they, in the first instance?
Yeah, I think that's highlights the importance of, I mean, we all talk about paperwork, and some are frustrated by it, some absolutely love it, and then there's everyone in between. But the simple fact of it is that this information being clear at the beginning of the services you're providing, saying this is exactly what I provide, and this is exactly what the cost is for, and maybe even managing their expectations in terms of what could happen. I always say, whether it's verbal or written, obviously written's better, but saying, look, this is what is intended to happen and that's what I will do, but all these variables could affect it. So if that happens, we'll talk about it, but it could incur extra costs such as XYZ. And just being, as long as a customer knows where they stand from day one, then there's generally going to be less problems, 10 days down the line, 10 months down the line, whatever it might be.
And taking it to an extreme. So most things I imagine you can probably deal with through sort of mediation, negotiation. I think one thing to flag from a Trustmark perspective is obviously any business that's registered with us, there's a 3-stage complaint process as well. So the first stage would be the consumer tells you about it, because if you don't know there's a problem, then how can you put it right? Frankly, it makes most sense. You are the contracting party, is that would be logical.
Yeah.
The second stage of that process under Trustmark would be escalating to scheme provider. So in this case, BPCA. Obviously, then you can do a role of mediating, investigate the issues, and decide actually has the business made a good call, or could they have sharpened up somewhere and support them with that, or whatever it might be. Again, that gives that reassurance that you've got all this information up front, and it's really easy to protect yourself. The final thing we have, and this is as much about perceptions as making sure everyone gets to an end point, is we have access through Trustmark to the Dispute Resolution Ombudsman. So member of the Ombudsman Association, and they are also CTSI sort of ADR approved, and all the stuff that has to go with that as well. And what that does is there's an ability for both mediation and adjudication, but taking that away from BPCA as well, because consumers might form a view that, well, of course you're going to side with your business because they pay your wages and subs and all this kind of stuff, right? Doesn't necessarily mean that that's the case. Doesn't mean anyone's done anything wrong. It can be a perception about bias, and actually what that does is gives us that completely independent view that everyone can kind of sit behind as an alternative, and then obviously protect folk from there. And that's where, coming back at the start of this, if you're really clear at the front end about services and risks and stuff, then they can say, well, actually that seems entirely reasonable, and therefore the consumer has no, in their view, no claim. And that will be strong evidence for you that, God forbid, someone did start a civil claim. Well, look, we've been through this process, and an independent ombudsman ruled in our favour. We've done everything right, haven't we? And that would be persuasive in the event of an actual claim, which is quite rare, but they do happen.
Yeah. Knowledge breeds confidence, isn't it? So, good. Okay. Well, amazing. Thank you so much for that presentation, Ben. Yeah, and like you mentioned, Trustmark and everything, BPCA members are a part of that. So yeah, we'll utilise you as much as we should. So thank you again.
Absolutely.
Merry Christmas.
Feel free. Yeah, have a good Christmas and a good New Year, everyone. All the best.
Great. Thank you so much. Fabulous. Well, that brings us almost to the end. We've got some association news and updates coming up from Scott Johnston, our Marcoms manager. He's going to cover that in a moment. But just before I go, just wanted to extend my thanks to all the speakers today and the topics that were covered. Got some great questions in there. Hopefully a lot of them got answered there for you. Also to our sponsors, Bell Laboratories, a huge thank you to you. And just a personal note from me. So today marks my last event with BPCA. I'm leaving BPCA at the end of this year. I'm not going to talk about it too much because I get upset, because I love BPCA. It's just an opportunity for me. But yeah, it's been a pleasure, and doing these events has been one of the things I've always looked forward to, and engaging with everybody and hearing all your questions. And yeah, I'm really going to miss doing it. Yeah, I just want to say thank you again to everybody and the support you've given me. And yeah, hopefully we'll all see each other at events in the future. And it's not farewell or anything forever. It's just farewell for now. And again, thank you for listening to me babble on. Okay, so thank you. And Scott, I will pass over to you for news association updates.
Thanks, Nat. Yeah, thank you for that. Hi, everyone. I'm Scott. I'm BPCA's comms manager. I just want to reiterate what Natalie said. So thank you to our fantastic speakers today, Stephen, Sophie, Michael, Ben, all of these people put their give us their time completely for free. They just to help run these sessions. We couldn't do these forums without them. So thank you to our speakers. Thank you in particular to Bell Labs and Michael from Bell Labs for being such a fantastic support to BPCA and sponsoring this event. We do really appreciate it. Obviously behind the scenes as well, there's a whole events team here at BPCA, Lauren and Sarah, making sure that these events run well, getting these speakers, making sure the agendas are action-packed for you guys. So a thank you to them as well for putting on such a impressive schedule of events this year. And then obviously it's sad to say goodbye to Natalie. Natalie has been running these online forums since they started. She's done our webinars, a lot of our online and in-person events. We're very much going to miss her on the BPCA team. She's our BPCA celebrity, and we wish her all the best for her new role in the new year. She's still going to be around. She's still in the sector, and I suspect she will still very much be in touch with BPCA and supporting us, her colleagues. So thank you, Nat. We really appreciate how fantastic you are during these amazing events. There's not a huge amount of industry news for me to go through at the moment. This is our last event of the year. It's been, like I said, an action-packed year of events. We've got loads more events coming up next year. We've got an events calendar full of 30 plus member and non-member events available for people to join in with. In particular, if you can get along to PPC Live in March, it's an in-person event. It's in Yorkshire at the Yorkshire Events Centre, and it's so much fun. It's the most hands-on trade show you can possibly go to. There's so much stuff to get involved in, so many training bites. So if you're a practically minded person and you like getting stuck in and seeing what's out there in the sector, please do make an effort to come along in March next year. PPC magazine should have landed on your doorsteps now. Again, that's got your latest news in it, some fantastic features in there, and a really nice Meet the Member article as well. If you're interested in getting involved in events or with the magazine, if you think actually you don't want to be watching or reading, you want to be getting involved and writing and presenting, definitely please do get in touch. We'd love to have you on, get your support. That's it from me. Thank you so much for coming along to this event today. Have an amazing Christmas. I hope everybody on this call gets a bit of a break over Christmas. And from everyone at BPCA, have a brilliant Christmas and a very happy new year. See you soon.